The I-130 is not just another form you fill out with USCIS. The I-130 is actually a petition. You are filing a case with the United States government. You need to know the difference. The I-130 application is one of the most commonly filed forms. And today we're going to do a walkthrough, a line-by-line walkthrough of the form so that you guys, when you get ready to ultimately file this petition with USCIS, you will make minimum to no mistakes at all. My name is Nasir Duncan. I'm a former USCIS adjudicator, and now I'm an immigration attorney. When I was adjudicating these cases, I could tell pretty quickly whether a case was going to be a clean case or a problem. Not because the relationship was suspicious or because the evidence was weak. It was basically because the application was filled out wrong. And every one of these errors either triggered a rejection or a delay. And many of these delays can last up to months and sometimes years. And that's what this video is about. I'm going to start sharing my screen in a moment and we'll start our walkthrough. Okay, before we start, we're going to go over the basics. Before we touch a single field, let's talk about some things that we need to get clear and have an understanding of. Number one, make sure that you look and see if you have the correct and most updated form right here. The one I am using today is February 28th, 2027 is when it expires. Make sure that you are using the most recent form. Now, who files this form? May seem like a silly question, but a lot of people don't know. The petitioner, the U.S. citizen, or the lawful permanent resident who is sponsoring their relative files this form. You are asking, or that person is asking the government to recognize your family relationship so your relative can eventually apply for a green card. The I-130 does not give your relative a green card. This is important. It does not give them any immigration status at all. It establishes the relationship. That's it. The green card application comes later through either adjustment of status or consular processing. We'll talk about that distinction when we get to part 4. Who is the beneficiary? Your relative, the person you're sponsoring, your spouse, your child, or parent or sibling. We'll see that at the top of the form when we get to part 1. And one more thing, if you are petitioning for your spouse, you also need to file the form I-130A, which is a supplemental form for the spouse beneficiary. That's a separate form. Don't skip it. USCIS will reject the whole package if the I-130A is missing from a spousal petition. Now, they may also issue an RFE instead of rejecting it, but don't even take the risk. Part 1, relationship. This area here on the left side of the form. This is where USCIS finds out who you are to the beneficiary. Question 1, I am filing this petition for my, and then you'll check one box, spouse, parent, child, brother, or sister. One box only. If you check more than one, you can cause yourself some problems. This seems obvious, right? But let me tell you what I saw as an adjudicator. People filing for a spouse would check spouse and also check something under question 2 about the parent-child relationship. Question 2 only applies if you are filing for a child or a parent. If you're filing for your spouse, leave question 2 alone. If you're filing for your sibling, leave it alone. Just check the box in question 1 that applies to you and move on. Question 2, let's move the screen down here so we can actually see it. Question 2, this is only for petitions involving a child or a parent, right here. It asks you to describe the nature of the relationship. Was the child born to married parents, born to unmarried parents, adopted, stepchild? Pick the one that fits. The reason this matters is because different relationship types have different legal requirements. A stepchild relationship, for example, is only recognized if the marriage that created the step relationship happened before the child turned 18. If it happened after, USCIS cannot approve the petition. So the box you check here isn't just administrative, it tells the adjudicator which legal framework to apply. Question 3, if the beneficiary is your brother or sister, are you related by adoption? If you're not filing for a sibling, skip it. Question 4, did you gain lawful permanent resident status or citizenship through adoption? This one applies to everyone. If you were adopted and that's how you eventually became a citizen or got your green card, you need to say yes. Why? Because there are restrictions. If you gain your status through adoption, you generally cannot file an I-130 for your biological parents. The law draws the line here. For most people, the answer is no, and you move on. That's part 1, 4 questions. And I can tell you from experience, part 1 is where the first mistakes usually show up. Someone chooses 2 boxes or checks the wrong relationship or answers question 2 when they're filing for a spouse. Small errors, big consequences. Please take your time. Okay. Part 2, information about you. This is regarding the petitioner. We're going to be still on the left side of the I-130 form. Actually, we're going to go to the top here on the right. And this section is pretty long. It goes from page 2 to 5. So let's take it piece by piece. Item 1 here is the alien registration number, also called your A number, right here. If you're a naturalized citizen or a permanent resident, you will have one. It's on your green card or your naturalization certificate. It will typically look like this here. Number 2, before I move on, if you were born in the U.S. and you're a U.S. citizen and you never had gone through immigration proceedings, you will not have one. Just write NA. Item 2, USCIS online account number here. If you file forms through USCIS online portal before, you will have this number. If you have not, leave it blank and move on. U.S. Social Security number. If you have a U.S. Social Security number, write yours in here. Okay, so full name. This is item 4 through 9. It seems self-explanatory, right? A lot of people make mistakes here. So please put your full legal name in here, your full legal name. Then any other names you've used. This includes maiden names, prior married names, nicknames that appear on official documents. Whatever name you've used that you've ever gone by that might show up in a government database, list it. If you leave any prior names off and USCIS finds it in their records, that creates a discrepancy. Discrepancies create questions, and questions create delays. Do yourself a favor and just list everything. All right, so we're going to go over to items 10 through 13. Basically, the addresses. This is significant because your current mailing address and your current physical address, if they're the same, mark them both on here, even though they're the same. USCIS will mail all notices about your case to your mailing address. So make sure you put it on there. If you move and don't update it, you will miss notices. This is a common thing, unfortunately. I've seen people miss their interview notices because they moved and didn't file a change of address form. A change of address form is an easy document to fill out. Don't miss any notices because you failed to update your your home address. 14 through 16, basically date of birth, city and country of birth. That's this information here. Country of citizenship, standard biographical information. You'll add all that information in there. Marital status. This is where it starts to matter a lot. If you are filing for your spouse, your marital status here needs to be married, obviously. But here's what the adjudicator is doing with this information. They're cross-referencing it against everything else in the file. If you say you're married now, but you were previously married, they need to see that the prior marriage ended legally. Divorce decree, death certificate, annulment, whatever it was, the paperwork needs to be in the file. And this is a mistake that I saw constantly. Someone would list the prior marriage, but not include the termination document, or they forget to list the prior marriage entirely. And then it would show up in the background check. When that happens, the adjudicator doesn't just ask for the missing document. They start questioning whether the current marriage is legitimate. You've now created a credibility problem that didn't need to exist. This is why I'm going through this form so slowly, to make sure that everyone understands. This is where the information goes right here. This is where you'll add your additional spouses if there are any. So now we're going to go over to items 36 through 39. Additional information about you. This information is highly critical. If you're a U.S. citizen, you select U.S. citizen and then tell them how you acquired citizenship. Not everyone that's a U.S. citizen was born here. Were you born in the U.S.? Were you naturalized? Did you acquire or derive citizenship through a parent? Each one requires different supporting documents. If you were naturalized, you need to provide your certificate number, the date it was issued, and the place it was issued. If you're a lawful permanent resident, you provide your class of admission, date of admission. The class of admission is the code that was on your green card or your I-94 when you were admitted. That's the travel document. Each one usually has a different code. So like usually three letters, three characters, like IR1, CR1, or F2B. Those are the class of admission codes. That code tells USCIS what visa category you belong to. If you don't know your class of admission, look at the front of your green card and you'll see the category. Number 40, class of admission, is the same as what we just discussed. Okay, 41. This one catches people often. If you obtained your permanent residence through marriage to a U.S. citizen or a permanent resident and the marriage ended, there are restrictions on filing an I-130 for a new spouse. You generally have to wait 5 years unless the prior spouse died, or you can prove the earlier marriage was real with clear and convincing evidence. This is a fraud prevention measure. USCIS takes it seriously. If this applies to you, talk to an attorney before you file. Okay, 42 is basically the employment information. Make sure you fill this information out. This information here, it's important but not critical. Just make sure if you have that information to fill it in fully so that you don't have any gaps or anything like that in your record. Part 3, biographic information. This is going to be the shortest part of the application. It's pretty self-explanatory. You're just basically putting in your biographic information, your ethnicity, race, height, weight, things of that nature. Okay, so all of this information right here, pretty straightforward. Put the information in and move on that. Part 4, information about the beneficiary. This is where you'll provide information about the person you're sponsoring, your beneficiary. This section is just as long as part 2, and it has some of the most consequential questions on the entire form. So again, we'll be going through this pretty slowly, trying to make sure that we cover everything so that as very little mistakes can be made as possible. Part 4, 1 through 3, the beneficiary's A number. Here, it's basically the same as we did for part 2, and it has some of the most consequential questions, as I stated before, on the entire form. If you don't have this information, write NA so that the officer doesn't think that you needed it and just didn't provide it. So, beneficiary's full name. Whatever documentation your loved one has that has their full name on it, their full legal name, the name that they have used on legal documents, put it here. If there are other names, make sure, as we stated in part 2, that information goes here. If you've ever used it, do not take the risk of not putting it on the form and then it popping up at the interview. And now you have to explain to an officer why you didn't put that information on there. Okay. So physical address, the same. Just make sure that whatever address your beneficiary is living at in the United States, that information goes on this form. They will also be receiving documentation from USCIS as well. So they want to make sure if they are in the country, that they have an address where they can be reached. Everything else on that part is pretty self-explanatory. I'm going to go down to 20 through 23. Here, the beneficiary's marital information is required. Number of marriages, current marital status, prior spouses, same as the petitioner section. We need the termination documents for these marriages, even if they are foreign marriages. This information is very important, especially with the spousal petitions. If the beneficiary was previously married and you cannot prove that that marriage ended legally, USCIS will question whether your current marriage is valid. No valid marriage, no approved I-130. Okay, 29 through 45 or so, beneficiary's immigration and entry information. This is all filled in. Do not leave anything blank. I had plenty of those when I was adjudicating these, and I hated to see those spaces because I would like to make decisions on these cases as quickly as possible. But we have to do RFEs or just flat out deny it. So save yourself the trouble and make sure you just fill in this information. Just go through the application quietly. Get in a quiet place and focus on, get all your documentation together and just fill it out. And this way you don't have to worry about it. If the beneficiary is currently in the United States, you need to provide their arrival information. This information here, the I-94 number, their date of arrival, their class of admission, where they were admitted, the current immigration status, and when their authorized stay expires. All that information goes over here, down here and over here. Beneficiary's employment information shouldn't necessarily have that at this point in the process, but there are different types of immigration situations, so there could be a situation where that's possible. If it is, make sure all the information is fully filled out. Here's the other section that we were just discussing. Class of admission, I-94, date of arrival, all that information goes there. Okay. If the beneficiary has ever been in removal proceedings, has ever been deported, has ever overstayed a visa, has ever worked without authorization, all of that needs to be disclosed here in the supporting documents. I need you to hear me on this. Do not lie on the form. Do not omit information because you think it will hurt the case. If the beneficiary overstays, say so. If they have a prior removal order, say so. If there's a criminal history, disclose it. USCIS already knows most of this from their databases. When you leave something out and they find it on their own, you haven't protected anyone. You've created a fraud issue on top of whatever the original problem was. There are legal options for almost every complication. Waivers exist, exceptions exist, but they only work if the case is filed honestly from the start. Okay, item 46 through 60. If the beneficiary used a passport to enter the United States, provide the passport number, country of issuance, and expiration date. Now, the most consequential question on this form, processing choice. Here, the beneficiary will not apply for adjustment of status in the United States, but he or she will apply for an immigrant visa at the U.S. Embassy or consulate in whatever country, city, country, or province that they currently live in, or if they are having to leave the country in consular process, that information goes right there. This is important here. The form asks you to choose one. Will the beneficiary request adjustment of status inside the United States? Or would the beneficiary go through a consular processing outside the United States? This question here, this is very critical information. The beneficiary is in the United States and would apply for adjustment of status to that of a lawful permanent resident at the U.S. Citizenship and Immigration Services Office. Either that or the beneficiary will not apply for adjustment of status in the United States, but he or she will apply for an immigrant visa abroad at the U.S. Embassy. I just repeated that, but it's very important to make sure that you understand what's going on with that one. If you picked adjustment of status, that means the beneficiary is already in the U.S. They're eligible to adjust, and they plan to file a 480 to get their green card without leaving the country. If you pick consular processing, that means the beneficiary will attend an immigrant visa interview at the U.S. Embassy or consulate abroad. If you check both boxes, USCIS does not know what to do with your case. If you leave both blank, same problem. They'll either reject it or use their own discretion to decide, and you don't want them making that call for you. If the beneficiary is in the United States and eligible to adjust status, check adjustment of status. If the beneficiary is abroad or is not eligible to adjust, check consular processing. If you've already filed and you realize you picked the wrong one, you can contact the USCIS contact center to request a change while the petition is still pending. This is the question I saw people get wrong more than almost any other, and the cost of getting it wrong was real delay. As I stated earlier, some of these delays can take up to weeks, months, and sometimes years. Part 5. Have you ever previously filed a petition for the beneficiary or any other? We kind of already went through this. I'll just say answer this honestly. If you filed a prior I-130 for someone else and it was denied, USCIS already has the record. They will compare the information in this petition to the prior one. If there are inconsistencies, that raises fraud concerns. You do not want to be in a fraud interview. If a prior petition was denied, understand why before you file again. And make sure the facts in the petition are consistent with what you said before, or explain why there's a difference. If you're a petitioner who obtained your green card through a prior marriage, and now you're filing an I-130 for a new spouse within 5 years, this is where the adjudicator is going to pay very close attention. Parts 6 through 9, this is the very end of the application. This is the information you'll see here. You select whether you read the form yourself or had an interpreter to read it for you. You provide your phone number and email, and you sign it and date it. Two things. First, the email address you provide here is the email USCIS and the National Visa Center will use to contact you. If the case moves to consular processing, make sure it's an email you actually check. Second, the signature must be in ink, not typed, not stamped, ink. If you file on paper and the signature isn't there or isn't in ink, the petition gets rejected. I've seen it happen. Part 7, interpreter's information. If someone helped translate the form for you, their information goes here. Interpreter information goes here. Preparer's information is 8 right here. Part 9 is additional information. This is your overflow space. If you ran out of room anywhere in the form, you can continue here. You can use as many copies of this page as you need. Just make sure each page has your name and a number at the top so USCIS can keep the pages together. Okay, that concludes my screen share of the actual form. So that's the I-130 line by line. I built this video to be a comprehensive walkthrough, but I understand that watching a video and sitting down to fill out the application are completely different experiences. So I put together a written guide that covers everything I just walked through, plus the full evidence package breakdown, a document checklist, and declaration templates. The link for that is in the description. If this video was helpful, please subscribe. I have other line-by-line walkthroughs coming in the near future, and I'll see you guys in the next one.